Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's nicest indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, there was a huge case to come out of the state of Pennsylvania. Actually came out of the United States District Court in Pennsylvania today. It's a huge case because it deals with two significant issues in one fell swoop, both of which are currently under petition to the United States Supreme Court. And it's an issue that we've been talking about at great lengths here on the channel, and it deals both with those who've been convicted of non-violent felonies and also those who are using controlled substances. The ruling today, I think, really telegraphs where the United States Supreme Court is likely to go. It begins to really develop the theory under which I think some of these laws are going to be struck down and some of these laws may be upheld. So today, let's spend a few minutes, let's get educated, let's break it all down, and let's talk about the huge case that everyone should notice. Okay, so the case we're talking about today is the case of Williams v. Garland. It is out of the United States District Court for the Eastern District of Pennsylvania. Mr. Williams, the plaintiff in this case, unfortunately had a long and terrible history of drunk driving in the state of Pennsylvania. He was arrested and charged not on one, not on two, but on three separate occasions. Obviously, by the time he got to his third DUI arrest in the state of Pennsylvania, the state of Pennsylvania had had enough of it, and he was sentenced to a rather lengthy penalty, and of course could have been subjected to far greater penalties had the trial court in Pennsylvania maxed the sentence out. Of course, because he had been subjected to a sentence of a year or longer, Mr. Williams then was ineligible to possess his firearm rights. Now, he filed this suit. Believe it or not, he filed the suit all the way back in 2017. He ultimately lost this suit, but then the case was reopened after New York Pistol and Rifle Association v. Bruin came out. Now, what's at challenge here is the constitutionality of 18 United States Code Section 922G1. That is the statute that says a person will be prohibited from possessing a firearm if they have been subjected to a sentence of a year or greater, which unfortunately begins to encapsulate a lot of crimes, because there are many crimes, not even of a felony nature in many states, where yes, the maximum penalty allowed by law may exceed a year, although in reality, individuals rarely, if ever, see actual jail time for those types of offenses. Now, what's actually being argued here is a motion for summary judgment. So what Williams is arguing to the court is, hey, listen, if you review all of the evidence and the applicable case law, and you just do it in light most favorable to the United States government, well, guess what? I, Williams, the plaintiff, I still win, because there really is no material issue of fact, and therefore, since the law is well decided, I'm entitled to a judgment in my favor as a matter of law. Now, it is a lofty burden to reach, and oftentimes courts will not grant summary judgments, but the court in this case has in fact granted summary judgment in favor of the plaintiff, Mr. Williams. The court, in announcing what needed to be demonstrated here, stated, summary judgment is appropriate if the movement shows that there is no genuine dispute as to any material fact and that the movement is entitled to judgment as a matter of law. And then, of course, the court launched in the very first few sentences of its discussion as stating, prohibiting plaintiff's possession of a firearm due to his DUI conviction is a violation of his Second Amendment rights, as it is inconsistent with the United States tradition of firearms regulation. And of course, the court first goes through analysis. Is this activity even protected by the Second Amendment? Obviously comes to the conclusion that it is, and then turns to the government to say, well, can you now provide a historical analog that shows us that we as a society have accepted these sorts of restrictions? The court was then quick to point out, the government has not met its burden in proving that the prohibition on plaintiff's possession of a firearm due to his DUI conviction is consistent with historical firearms regulations. Now, this is where the court starts beginning to carve out what I think is going to be Very indicative of the ruling we're going to get in United States v. Rahimi. I do believe that the United States Supreme Court is going to carve out a dangerousness exception to many of the restrictions under 18 U.S.C. section 922G and state that individuals who have in fact been deemed dangerous because of prior conduct can be disarmed. But those deemed irresponsible or unlawful, well, there will not be a presumption that that type of restrictions would be constitutional. What makes me say that? Well, the court using language such as this: that federal law has, over the past century, allowed for the disarmament of certain types of convicted criminals does not satisfy the constitutional issues raised by applying section 922G1 to all convictions punishable by more than a year of imprisonment. And the court also pointed out, instead the court must consider more long-standing limitations on firearm possession to demarcate the scope of the constitutional right. And then ultimately the court begins to announce that, hey, listen, we're willing to accept a dangerousness standard here. The problem is this plaintiff does not necessarily fall under that standard. As the court put it, although this court remains quite concerned about the prospect of granting access to firearms to persons who have demonstrably abused alcohol, it is not convinced that the general dangerousness of drunk driving and of combating firearm use and alcohol consumption establishes that DUIs must therefore be considered sufficiently analogous to historical examples of dangerous conduct that have previously served as grounds for disarmament. And again, I think that there would be a real different analysis here if there'd been considerable evidence to show that there'd been multiple occasions of Mr. Williams being intoxicated while possessing or using a firearm. But that was not the allegations. In fact, there was nothing on the record to suggest that on any one of the 3 DUIs, he was actually armed with a firearm at the time of the traffic stop. The court also, in again, trying to really establish the difference between irresponsible, i.e. what we're going to get in Daniels versus the United States and Range versus Attorney General of the United States, versus dangerousness, which what we have in United States v. Rahimi, the court went on to state, however, that legislatures have historically labeled certain groups and conduct dangerous for the purpose of disarmament does not in and of itself create a historical analog to the present-day prohibitions on firearm possession by those convicted of DUIs. Historical regulations on persons deemed dangerous do not present a sufficient historical analog without showing that the regulated conduct itself is analogous to the plaintiffs. And so you can see here the court is more than willing to accept a dangerousness standard as the ability to disarm an individual. What they're saying here, though, is the United States government has not established that Mr. Williams, the plaintiff himself, falls into that dangerous category, because even though drunk driving is undoubtedly dangerous, and unfortunately the National Highway Traffic Safety Administration has plenty of statistics to prove that, Mr. Williams has not shown that he is dangerous while armed. He clearly, however, is dangerous while intoxicated. And of course, the government then says, well, hey, there is a long history of banning firearms from those that are intoxicated. That is partially true, but as the court pointed out, the government points to several regulations permitting the disarmament of drunk or intoxicated persons. None of these regulations allude to the disarmament lasting beyond the individual state of intoxication, and none provided for permanent disarmament. But what the court concludes with here is what really, I think, kind of gives us the looking glass into what's likely to happen in United States v. Rahimi and what's likely to happen in United States v. Daniels and Range versus Attorney General of the United States, 2 cases dealing with non-violent felons and cannabis users that are currently being petitioned to the United States Supreme Court. And that is that there absolutely appears the willingness by even conservative courts to carve out a dangerousness standard for disarmament of civilians. However, the line appears to stop right there, because as the court put it, additionally, a DUI cannot be considered to belong to the class of convictions, namely for crimes of violence, for which there is a long-standing regulatory tradition justifying permanent disarmament. Therefore, Plaintiff's DUI cannot be categorically defined as a crime of violence for which there may be historical support for Second Amendment restrictions. So again, when you try to read between the tea leaves, and you know that United States v. Rahimi has already been argued before the United States Supreme Court, you know that the United States government is now appealing both the United States v. Daniels and Range versus Attorney General of the United States, I believe that this particular case, Williams v. Garland, really does provide us an amazing sneak peek at what we're likely to see the United States Supreme Court do when encountered with all of these issues. Listen, we'll link the opinion up down below so that you can geek out on it one more time. The case, once again, is Williams v. Garland. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's down there in the description box as well. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.